Hello everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty here at iExamB. In this video today, I'm going to discuss with you all the landmark cases from the subject of criminal law, especially for CBI APP exam preparation. Those who are preparing for the exam, your exam is nearby on 17 December and आपकी preparation I hope अच्छी चल रही है. I wish you all luck for your exam and ये cases का एक रिवीजन आपके लिए काफ़ी अच्छा रहेगा कि कुछ इंपॉर्टेंट केसेस मैंने इस वीडियो में आपके साथ डिस्कस किए हैं जो काफ़ी लैंडमार्क है फ्रॉम द सब्जेक्ट ऑफ क्रिमिनल लॉ. सो वॉच दिस वीडियो टिल द एंड. आप इसके साथ जो पीपीटी है उसको भी डाउनलोड करके रख सकते हैं. अगर आपकी क्वेरीज हैं कोई, यू कैन रीच आउट टू अस बाय राइटिंग अस एन ईमेल ऑन hello@iexamb.com. यू कैन ऑल्सो कॉल अस ऑन दिस नंबर 9205524028. आप इस वीडियो को पॉज करके नंबर नोट डाउन कर लीजिए. अगर आपको कोई कोर्सेज का डेमो चेक करना है, ऑनलाइन कोर्सेज अवेलेबल जो है iExamB पे, आप वेबसाइट पे जा सकते हैं www.iexamb.com पे एंड यू कैन चेक आउट द डेमो ऑफ द कोर्सेज एज वेल. So don't forget to subscribe to LegalB as we keep on providing you strategic content and what not on in the form of videos at LegalB for different exams. So CBI APP exam. Why am I discussing cases chiefly? First of all, many students have requested for the same, and in this exam case laws are asked from certain areas. Definitely cases are asked like criminal law, constitutional law. तो अगर आप इस एग्जाम के लिए प्रिपेयर कर रहे हैं तो आप केसेस देख के जाना मत भूलना. Go through the cases as much as you can. This video is not giving you an exhaustive list जो possible तो नहीं है, but I will be discussing some very landmark cases which have made some very important and significant contributions in the field of criminal law. So इस वीडियो में हम लोग वो चीज़ें कवर करने वाले हैं. आप इसके साथ जो पीपीटी है वो भी डाउनलोड करके रख सकते हैं फॉर योर रेफरेंस एंड यू कैन रिवाइज इट इन द लास्ट मोमेंट एज वेल. So cases, how you have to study. Don't worry about the cases, you just have to read the summary of each case and which is the important case that you have to focus on, what provision it was dealing with or what contribution it has made in the field of law. That is something which is important. All the facts you don't have to remember. So first ये fear अपने माइंड में से निकाल लीजिए. काफ़ी स्टूडेंट्स को लगता है कि इसमें जो फैक्ट्स हैं हमें वो भी याद रखने हैं क्या, एंड ऐसा कुछ भी नहीं है. आपको सिर्फ एक ब्रीफ समरी याद रखनी है. अगर क्वेश्चन आएगा भी तो इतने डीप फैक्ट्स में से नहीं आएगा. इट विल बी फ्रॉम प्रोविजन एंड व्हाट कंट्रीब्यूशन दिस केस हैज़ एक्चुअली मेड. आई विल टेल यू द केसेस. आपको वो केसेस सुनने के बाद समझ में आएगा कि क्या एरिया आपको बेसिकली हर एक केस में फोकस करना है. So the first case that I'm going to discuss is Tukaram versus State of Maharashtra, the custodial rape case. This was a very heinous crime or offense that had taken place, and in this case what was held basically जो ratio है मैं वही आपको इस वीडियो में बताने वाली हूँ, that the onus was on the prosecution to prove that all the ingredients of section 375 that is rape were present in the case of sexual intercourse attributed to the appellant. The nature of consent of the victim had to be determined from the circumstances, and the circumstances made it clear that the consent was not passive. So consent के बारे में क्या important point कहा गया है यहाँ पे कि एक्टिव कंसेंट होनी ज़रूरी है, पैसिव कंसेंट नहीं. सो रेप में सबसे इम्पॉर्टेंट डिफेंस क्या है? कंसेंट. सो इफ़ यू आर टॉकिंग अबाउट कंसेंट, द कंसेंट शुड नॉट बी अ पैसिव वन, then it will not act as a defense. Criminal Law Amendment Act 1983 was enacted because of this case, which changed section 114A of the Indian Evidence Act, which specified that permission is not implied unless it is expressly granted. So यहाँ पे एविडेंस एक्ट का भी रेफरेंस आएगा, आईपीसी का भी रेफरेंस आएगा. ऑब्वियसली इट्स अ कॉम्बिनेशन. The sentence for custodial rape was increased to 10 years and the onus of evidence was placed on the accused after sexual contact was established. I hope everybody knows onus, burden of proof. ये भी काफ़ी important areas हैं आपके लिए. Section 376 of IPC changed by making custodial rape punishable and by defining it. This is one landmark case relating to rape. Lakshmi versus Union of India acid attack से related case है ये. This case has provided guidelines for the advancement and development of laws that are relating to acid attack offences. This case provided for the amendment in laws for acid attack in the IPC, and these are the sections that are dealing with acid attack 326A and 326B. कई बार वो आपको क्वेश्चंस पूछ लेते हैं. ये केसेस पढ़ने से आपको एक और फ़ायदा ये भी होता है कि कुछ इंपॉर्टेंट सेक्शंस भी आप याद रख सकते हैं बार बार आपके आंखों के सामने आने की वजह से. एसिड अटैक का सेक्शन कौन सा है? इट्स कवर्ड अंडर एन अमेंडमेंट टू ग्रीवियस हर्ट सेक्शन. Punishment for throwing acid offense, and in CRPC section 357A and C were inserted. So victims को compensation के लिए जो scheme आई है वो acid attack survivors को भी applicable है. So CRPC में भी ये amendment आया. तो this is very important case in criminal law. IPC CRPC दोनों में amendment आया है. Acid attack victims can get treatment from any hospital without any expenses. Any hospital, not only public, any public, private. This is also one important area to remember. To be remembered, that is CRPC. You have to remember it. Then KM Nanavati was the state of Maharashtra. Everybody knows the facts of this case, but nobody remembers that this is the case. This is the name of the case. जिसके ये facts हैं. So, Supreme Court has in this case held that the accused's conviction under section 302 of IPC and sentence of life imprisonment imposed by the High Court is legitimate. So, ये जो case है ये काफ़ी important है. ये actually adultery was the cause, जो wife की adultery के वजह से एक जो accused है यहाँ पे he got grave and sudden provocation. This was the defense that he had taken. And he had confessed also. The element of suddenness of killing was missing in this act, and because 3 hours had transpired between the time of confession and the time of killing, so the court concluded that a reasonable man had enough time to cool down since the provocation. So this is one important point which we have to remember here, that within 3 hours a reasonable man will cool down. Sudden provocation की अगर आप बात कर रहे हैं तो वो 3 घंटे का टाइम काफ़ी है. This is something which has been interpreted by the court in this case. So basically 302, 299, 300 and 299 sorry. ये दोनों के बीच का जो डिफरेंस है, क्योंकि कुछ एक्चुअली तो 299 में एक अलग कल्पेबल होमिसाइड का वर्ड है, 300 के ही एक्सेप्शंस में ये क्लेम किया जा रहा है यहाँ पे, बट अल्टीमेटली दैट इज ऑल्सो मर्डर, कल्पेबल होमिसाइड नॉट अमाउंटिंग टू मर्डर. ओके, सो कल्पेबल होमिसाइड की बात की गई है उसमें. This case has established superiority of law. Jury, influenced by the media and public opinion, delivered an unfair but celebrated verdict wherein Commander Nanavati, accused under section 302, was initially declared not guilty by a jury. It was then referred to the higher courts, which later held the accused guilty of the crime that he committed. This proves that the law remains the same for everyone, irrespective of one's status or class, and is superior to all in the land. इस पर एक मूवी होने की वजह से काफ़ी लोगों को इस केस के बारे में पता है, लेकिन एग्जैक्टली उस केस में जूरी के डिसीजन के बाद भी क्या हुआ था, दैट ऑल्सो यू हैव टू स्टडी. यू हैव टू स्टडी द लॉ पॉइंट्स एंड दैट यू हैव टू रिमेंबर द नेम ऑफ दैट केस एंड एवरीथिंग यू हैव टू स्टडी इन डिटेल. मूवी में जो फैक्ट्स बताए वो थोड़ा लिमिटेड बताते हैं, आपका लॉ पॉइंट ऑफ व्यू से पूरी तरीके से पढ़ना ज़रूरी है. Mukesh and others versus State of NCT of Delhi. Now this case everybody knows by the common name Nirbhaya rape case. This is very landmark judgment. It is comparatively recent to all the other cases that I am discussing, but it has made a major contribution in criminal law as it has directly got an amendment in criminal law in 2013. So this is also an important case for you. इस तरीके के जो भी cases आपको मिलते हैं ये आपको पढ़ने ही हैं. Remember that. You take this video as a guidelines, and if you get more content, you have to read on it. Definitely you will be getting. This is not an exhaustive list. In a simple mandate, the court stated that the diabolic act has shaken the common consciousness of the nation, and that the court should regard it as the rarest of rare cases in which death sentence could be avoided. Because the act of rape in this case was very heinous. That's why the court has confirmed the death sentence in this case, because rarest of rare doctrine is being complied in this case. The bench has made the remarcations. All the evidences were available against all the accused. Bench said that the way they played with the identity body, dignity, and privacy of a woman is unforgivable, and their evil deeds had no mercy to be given. So, this kind of case is perfect for death penalty. Only one person who was the juvenile offender was escaped, and one had committed suicide. Remaining all had been hanged. So, Criminal Law Amendment Act 2013 was passed as a direct result of this case only. A lot of public opinion was gathered in favor of Nirbhaya and against all those culprits. So IPC, Indian Evidence Act, and CRPC were amended relating to the sexual offences. So this is also an important area. Again, as we are talking about death penalty, we do have to cover Bachchan Singh versus State of Punjab. There are many cases in this area as well. We can also cover the cases relating to Aruna Shanbag and suicide and all. I will try to cover that in the next video if possible, or I'm going to deal with constitutional law. So in Right to Life also we can cover that. If not, I'm telling you now only those landmark cases also you have a reference. Bachchan Singh versus State of Punjab, talking about death penalty. Supreme Court's decision in this case is regarded as one of the landmark decisions on the issue of death penalty. When a death sentence is imposed on someone, it captures the attention of the entire nation. In this case too, the entire nation was waiting for the Supreme Court's decision, which stated in its majority decision that Section 302 of IPC and 354(3) of the CRPC are constitutionally valid. Doctrine of rarest of rare cases for imposing the death penalty is still in use today in gravest cases of extreme culpability. Only in those cases rarest of rare doctrine will be used, and in other cases there is not always a need to resort to death penalty. Basically, what was the thing, that death penalty was to be an exception, is to be an exception, and imprisonment for life should be done generally instead of that, and that is being followed as well. Supreme Court has stated that should be done only in the rarest or more rare cases where the alternative opinion is unquestionably foreclosed. Now, Tej Singh Johar and others versus Union of India. Homosexuality is related काफी landmark judgment. It is not a crime. It was held that Section 377 of IPC is unreasonable, indefensible, and unconstitutional. So portions of law relating to consensual sexual acts between adults were considered as unconstitutional, but then the LGBT rights were getting affected because of that. So this was a celebrated judgment for that, very landmark. Majoritarian views are relating to the traditional morals. You cannot go by that. After this case, there was decriminalization of all consensual sex among adults, including homosexual sex. Joseph Shine judgment also has to come here today because adultery is not a crime. This was also a very celebrated judgment. Joseph Shine versus Union of India. 497 of IPC has held that this section is violative of 14, 15 and 21 and declared it unconstitutional. ये judgment constitutional law के angle से भी important हो जाता है यहाँ पे, and IPC में criminal law में भी, because it is no more a crime now. It has been declared as violative and unconstitutional, because in that, what is the interpretation of that provision, that woman is a property? So that is something which cannot be done. This kind of interpretation or ideologies in our laws we cannot follow today. This provision was considered discriminatory, and therefore a progressive approach has been adopted, and the provision has been struck down, putting an end to the adultery law. So the adultery law has been put to an end. Court held that while there might be negative effects of the failure of parties to a marriage to be faithful to each other, it would be left to the parties to decide how to proceed, whether by resorting to divorce or otherwise, and introducing criminal sanctions would serve no purpose for this. It is their own decision of the parties. On that ground they can take a divorce, but if we are putting criminal sanctions for that, and then if that is leading to an interpretation that is treating wife as a property of the man, that is violative of 14, 15 and 21. So this was the ratio of the judgment. Mohammad Ahmad Khan versus Shahbano Begum and others. Again an important area, maintenance related काफी landmark case है ये. Supreme Court has in this Shahbano case concluded that Muslim husband's obligation to provide maintenance to a divorced wife who was unable to support herself extended beyond the iddat period. मुस्लिम पर्सनल लॉ के हिसाब से अगर कोई प्रोविजन है, लेकिन हम 125 पे की अगर बात करते हैं, दैट इज गोइंग टू प्रिवेल. दैट इज द मोस्ट इम्पॉर्टेंट थिंग. Supreme Court has ruled that Section 125 of CRPC applied to all the citizens, irrespective of their religion, without any kind of discrimination. Court clarified that 125(3) of CRPC was applicable to Muslims as well. So this is very, very landmark judgment in the field of personal law, in the field of maintenance, family law, and women rights. So it was emphasized in this case of any conflict between 125 and Muslim personal law, 125 will prevail. DK Basu versus State of West Bengal. Again, one more area I have tried to cover over here. Arrest, arbitrary arrests were increasing a lot. So this is very important in criminal law also and in constitutional law also. This case is very important. Public interest litigation was questioning in this case about custodial deaths and violence that is taking place and the arbitrary acts of the police personnel when they are exercising their powers of arrest. Supreme Court has laid down detailed guidelines in this case. Basing on that, we have amendments in CRPC now. So those amendments are really, really important for you people to be studied. And this case entirety, I would suggest you to read the guidelines also in detail and correlate that with CRPC and the amendments. Like for example, notice has been added. वो सब आपके लिए बहुत important है. Do go through it. जितना मैंने दिया है ये सिर्फ एक इंट्रोडक्शन है आपके लिए. मैं सजेस्ट करूँगी कि आप CRPC में उसके प्रोविजंस पढ़ें और गाइडलाइंस को एक बार अच्छे से पढ़ ज़रूर लें और इसके फैक्ट्स भी पढ़ते हैं तो आपके लिए अच्छा होगा. स्टेट इन्वेस्टिगेशन एजेंसीज़ के बारे में और जो गाइडलाइंस फॉलो करने चाहिए, क्योंकि अगर आप CBI के लिए APP के लिए एग्ज़ाम दे रहे हैं तो डेफिनेटली ये जजमेंट आपके लिए काफ़ी इंपॉर्टेंट हो जाता है. आपके काफ़ी सारे पॉइंट्स इसमें क्लियर हो जाते हैं. यू हैव टू अप्लाई अ प्रैक्टिकल अप्रोच दैट व्हाट कैन बी रियली रियली इंपॉर्टेंट फॉर योर एग्जाम, सो यू डोंट हैव टू स्किप दैट. It related all cases dealing with arrest and detention. This case is widely considered, as I already told you, in criminal jurisprudence. Very, very important case this is. And again, CRPC was amended in 2008 and it got effective from 2010. So what were the amendments? I would suggest you to check them out. So this was all. Though the list is not exhaustive, but I have tried to cover different areas and give you an introduction that which kind of cases, how comprehensively you have to study the cases from the subjects. Now from criminal law, we have covered various judgments in this one particular video. You can subscribe to Legal Bee and stay updated with all such kind of videos. And once again, all the best for your exam preparation. This video is also relevant for other people who are preparing for law exams, for judiciary, and even for practicing advocates, because it is having various landmark judgments compiled together. So watch this video till the end. If you have any queries, you can write to us in the comment section as well. Thank you, everybody.